Hey everybody, welcome back. Then the jury will come back, and the first thing that will happen is the judge will ask everybody to stand that's on the petit jury or the 12-person jury and ask them to swear to listen, stay attentive, and do their duty as jurors. Once everybody swears in, the next words you'll hear be from the state in an opening statement. If you'll think of it as a crossword puzzle, not a crossword puzzle, a jigsaw puzzle, where you get to look at what these pieces should look like. We are telling you in broad terms what this case is about, so that when person A comes to the stand, you'll say, oh gosh, I get that, I understand what that's about. The defense gets to come up and they get to give an opening statement also, and they'll say why a piece of the puzzle shouldn't fit or whatever take they've got on it. Immediately after that, the first witness will take the stand. He will swear to tell the truth, the whole truth, and nothing but the truth. And then he will take the stand, and the prosecutor will ask them questions. They will be very short questions because we can't lead the juror. The defense, once we are through with that witness, getting the story out as we can, the defense gets to get up and they get to ask cross-examination questions, which are a lot longer, but it's a leading question. And it would be like, and you really didn't see what went on Friday night, did you? So it's a long question with a did you, or something that turns it into a question at the end. You'll see the answers being fairly short, like no or yes. At the end of that, we'll put up a second witness and a third witness until the state's case is complete. Then there will be a motion for a directed verdict. It happens every time. The defense says the state, by and through its witnesses, didn't prove the case. Judge, take it out of their hands and let my man go home. Generally speaking, the directed verdict motion, if there is any evidence in there that would sustain a verdict of guilty, the judge will let it go to the jury. Then the next part is the defense gets to choose whether or not to put up anybody or not. They may want to put up witnesses. If they do put up witnesses, they lose their ability to do their closing statement last, because the burden of proof is all on the state. So a lot of times people will say, I don't want to put up anything. It's not my burden to prove anything. I'm not putting up any witnesses. And then they get to have the last word before the jury goes out. But if the defense puts up a witness or two for a critical point, then they get to ask those questions, and they're not good at it for the most part because they're just used to cross-examine questions. So they ask a lot of leading questions, and then it's up to us to say, Your Honor, we object. That is a leading question. And the judge, at some point, they'll get on board. It's a new process for them. They'll get on board and start asking very short questions with longer answers, just like we had to do in our case in chief. And we get to ask cross-examination questions, like, you really love your son, don't you? Yep. Okay, no questions. That's the way it kind of works out. At the end of the defense case, if they tend to put up anybody, if they want to, then there will be a closing statement, and it is the state and the defense telling what their take on the whole process was over the 3 or 4 days, trying to tie it all together, because you'll hear a little bit from witness number 1, a little bit from witness number 2, and because we're in a courtroom and there's just a magnitude of rules, it really is hard to tie it all together, because there's certain things you can't ask, there's certain things you can't say, there's ways you got to say it. So if we're able to do that, then we will tell you how 1 and 2 fit together and how 3 and 4, and this is why we believe that is proof beyond a reasonable doubt that a crime was committed and committed by this person. The defense will get up and tell you that they believe that there's holes in the story. All of that is closing statements. You've seen that on TV a million times. That's really what people tune in to watch. At the end of that, the judge, this is not what the people tune in to watch, but the judge will read straight off of a charge book, and he will talk to them about certain issues of law, a preponderance of evidence, the fact that the defendant is not guilty or innocent until proven guilty, all of those standard charges. That'll take about an hour. At the end of that, you've had direct and cross-examination of all of the witnesses. You've had opening and closing statements, and now you've had the charge on the law by the judge. The judge will send the jury out to deliberate. And at the end of that usually all of that goes on in about a week. And then we are through with it. The jury will come back and they will agree as a group with the indictment that has been given to them. They'll mark it guilty or not guilty. And if they mark it guilty, then the judge will have to sentence along ranges that the legislature has said this is what this crime should be for. So in murder cases, the mandatory minimum is 30, the maximum is life, or could be the death penalty. In breaking into a car, the mandatory minimum is 0 days, and it could go up to 5 years. But the state legislature sets those amounts. So the jury comes back, they tell the judge what they believe, that the case is either proven beyond a reasonable doubt or not proven, and then the judge sentences, and that is what happens during the course of a week, really quickly. Come back next week, I'll fill you in, good, bad, or indifferent, on how this case went.